But it's, to me, what it is a lot of whānau out there will feel pressured to do what they're told to do. And if you're anything like us, it's basically get stuffed, we'll push back. Because at the end of the day, when you like, I mean, when Jess had her lawyer, you know, when you've got a lawyer that's, oh yeah,
oh yeah,
when you get your case files and you find that your lawyer was telling OT, yeah, I'll see if I can get the video from her so that I can give it to you, right? That's time for the lawyer. It's time for you to do something yourself. I mean, we started out like everyone else. You don't have a clue what you're doing, but if you're really wanting to pursue it, like I said on one of the posts I put up, you know, it wouldn't matter which one of my kids it was or which one of my grandkids it was, okay? If someone's going to come after them, then I'm going to do my best to stop them. I suppose the thing that I've learned over time is pass that knowledge on. Because if you don't pass that knowledge on, we're going to have another 6 decades of people still going to Royal Commissions in 60 years. I told the social worker when we first went into the office about Bubba's case, I was in their care from 14 to 16. So at that time, I turned and says, I can see that obviously nothing has changed in 34 years. And she goes, what do you mean by that? I said to her quite simply that you're still operating in the same way as you did back in 1985. I would say the things that you've got to look out for is, if you go to a whānau hui, like I've just been to with someone else, okay, whānau huis don't have a safety plan. Okay, they will try and implement a safety plan. The one I just went to, I turned around and said, no, there's no reason for a safety plan to be put in place. It's not covered by legislation under a whānau hui. It's not even covered by hui whānau. The only one that is covered by it is an FGC. Oh, but we must put a safety plan in place. No, you don't, because you don't even need to intervene. And the other thing I just came to know just lately is, like I've always said to people, and I still believe this, okay, you go to an FGC and you agree to care and protection concerns to get a plan in place. You've just agreed to have your kid go into care at some stage.
The thing that Francis said.
Yeah. Oh yes. The other thing that people need to know. Okay, when I had an understanding of it, but then I got a final understanding of it at the hui whānau that we had. Okay, the FGC coordinator for it brought up about the fact that under Section 28B of the Rangatamariki Act, okay, the whānau do not have to agree there's care and protection in regards to the child. They can just agree that changes need to occur for the best interest of the child.
So basically manipulation.
Yeah, so it's by going 28B, you remove the care and protection side of it. However, what I would say to that though is this: it may be in the legislation, but the wording of it, yes, it does say that. However, we know the people behind the bench interpret it in their own way.
And this is
so I would still always say to people, don't agree to care and protection. Never agree to care and protection. It doesn't matter who's saying to you, just by agreeing to care and protection to get the safety plan in place. Okay, you want a safety plan in place, go to court, get the court to order that safety plan happens, not then. Because at the end of the day, that we know for sure from our FGC, okay, we were told by Judge Black at the hearing, but you agreed to care and protection at the FGC. It may have been under duress, but you still agreed. Because her lawyer at the time, she ended up having a word to us, because back then we knew nothing, right? And she said, look, if you guys don't agree that she's in need of care and protection, they will take her today.
So that's the only reason we
agreed. The only reason we agreed. But what I have found is, yeah, exactly. So that's one thing I can't reiterate enough with people is, when you go to an FGC and you agree that there's care and protection, even if you know there's care and protection concerns, you don't agree to it because it unlocks the key to the 101. So here's what happens when you go to a courtroom. You've agreed your child's in need of care and protection, so the minute you go to a hearing, that hearing's already decided before you start it, like ours was. And so
the way I I said is, if you're going to agree to care and protection, that your child's never care and protection, I was like, here you go, have my child. Because that's what you're basically doing. Don't agree. They will always come back. You agree.
Yep.
That's it. End of.
The important things for them to realise, people out there to realise, is place of safety warrants, Section 78. Place of safety warrant, 5 days to do a notice of intention to appear. Section 78, you've got 14 days, sometimes 21. If you do a Section 139 interim agreement, okay, the interim agreement is not an interim agreement. Can't stress it enough. 139 leads to 140. Okay, so 140, that automatically, from 139, they're automatically going to go to a 140 agreement. 140 is seen as being you agreed to have your child under a 101. So with the 140 in place, you just agreed to care and protection without knowing you agreed to care and protection. So the minute that they go, there's a clause in there where you can cancel that agreement within 7 days. However, you've got to be crafty about it, because within that 7 days, as soon as you go and cancelling it, they apply to the court for 101, because 140 is 101. So those are the things, those are the orders you've got to be careful of, because even though they will sign an agreement with you, but the child will stay with you, okay, where's your ticking time bomb? When's it going to go to a 101? Because 139 can only be done twice. Once it's been done twice, it goes to 140. They don't have an option but to go to 140. But they get you to sign the paperwork saying it's the same agreement, but it's not, because 139 is a temporary agreement, okay, and the temporary agreements are supposed to go for 6 months, okay, and 140 is 1 year. Okay. The other thing that people don't know is under guardianship orders, a 110, okay, is an interim order, right? Sorry, 110 AA is an interim order. You can only have 2 of those over 2 lots of 6 months periods. Once those 2 6-month periods are gone, your child is now subject to a permanent guardianship order under them, automatically. And it's always going to drag on for more, because under 1342, an under 7-year-old, a plan has to be done for a 6-month period. Over a 7-year-old, it's for a year. Now, when they come up to review time, like when those plans go in, it's a 186 report and a 128 plan that goes before the court. They have to be subject to Section 130, which means the court's decided the plan is adequate and appropriate.
That's the important part. That's
the important part, because without the 130 being done, you cannot do 101. Okay.
And without it being approved by the court.
And it must be approved by the court. Here's the catch: when Bubba was first uplifted, and they put the plan in, it never got approved. Illegal uplift. Well, you can't agree to something they never talked to you about.
Exactly.
And so what they did was they talked with the father's family and sorted it all out through there. The part that I found disgusting at the end was when, after we hit the Hui whānau, the social worker came to the house, and she was just doing her normal 8-weekly check. But what she came out with, that was what disgusted me. I work with the family that's got the child. I don't work with the other family. That's how we're trained. So how does the other side of the family that doesn't have the child ever get contact, ever get any rights? Because OT is training them not to have it. And so do I believe we would have had a chance in court? Yes, on the judicial review, because of the way we had changed the paperwork. Do I believe we had better chance and easier chance through settlement? Yes. So I was better to, basically, you use the judicial review or appeal process, this is what I have found, to then seek settlement with them. Because they will want to do the settlement based on the fact, like, when we changed the paperwork and we had the case laws and everything like that, and the judgments to put in your referencing, okay, that was when how they did their paperwork changed completely, right? Because originally we were putting our submissions in, they're just writing back normal submissions, right? Because what you got to understand about the submissions, and you understand this now, is that if you don't reference case law to say someone else won on this fact, right, then they don't care. They don't listen. You can go into a hearing like with having done your affidavits. Okay, here's what I'm going to say: affidavits don't mean shit. Okay, why? because when they get you to write out an affidavit, you give your answer to what you say happened, right? No, you're giving your view or opinion or position on their allegation. What does that do? That nullifies your affidavit. You've just spent all your time writing it out and giving what the lawyers asked for, but the issue becomes you just nullified it. You just cancelled out your whole affidavit because it's going to have your opinion of what they've said on it. You can't have a view, an opinion, or a position on it. You can do that in submissions, you can do that in applications, but your affidavit can't contain any one of those things. Like they might turn around and say, well, I believe that their mental health needs looking at, right? Here's what I would write now. I cannot give an answer as that is their view. How they say critiquing reports, okay, you can critique any document. All you've got to be able to do is go, that contains a view, that contains an opinion, and that contains your position, right? So if you've got any one of those three within an affidavit, you've just cancelled your affidavit. But no parent knows that, so they're answering it, and that's what a case goes on forever. If they turn around and, like, for instance, they might turn around and say, I have seen a person, this person used drugs on this date, right? Okay, I would simply answer that by stating paragraph, say for instance paragraph 15. Paragraph 15 imparts their view on what they say they allege I have done. That way, it's not your view. You're pointing out it's their view. I spoke to a judicial officer barrister down south, and what he said to me was, when you do affidavits, I was like, yeah. He goes, I said to him, like, I told him what I've started doing is I'm referencing in, like how we do the case laws, I'm referencing in the evidence into the submission. And then on my affidavit, I'm just saying that, well, you just say you rely on what's contained within your submission, right? Because an affidavit can be struck out due to the fact that it contains opinion, like I say, opinion, view, or position, right? But if you're referencing the document, it's now an authority, so you don't need the affidavit. You still need to file an affidavit, but you're relying on the contents of your other paperwork. You also remove one other thing. You remove the opposition's ability to cross-examine you because you don't have an affidavit. You don't have evidence through affidavit. You've got authorities referenced in it, so therefore those authorities hold more power than the evidence. Here's the good part about it. The Evidence Act hearsay doesn't apply anymore because it's not in an affidavit. When you read, like, if anyone who's ever got a judgment, if you read through the judgment, you'll see where it's got the word, it's got the little footnote number. You go down the bottom, it gives the reference to it. You know that, right? But a lot of people out there don't. But that part there, in your document, when you're writing your own document, it removes the need for the affidavit. Sorry, the contents of the affidavit. Put the contents of what you're going to put in an affidavit and exhibit, reference them as footnotes, and cite them. So the part you're depending on or leaning heavily on, copy and paste that into your document and then reference it at the bottom. You've now got a referenced footnote that holds more weight than an affidavit. All family court cases, I'm going to go straight out and say this, all family court cases, okay, they at some stage will have either breach of natural justice, okay, every single one of those is going to have breach of natural justice because, in my view, the judicial officers just can't control themselves. So they always do breach of natural justice. And the most powerful case law that I have found in regards to that is Maharaj number 2, which was from 1974, and is, 1978, is 44 years old, and as the Supreme Court put in a 2010 judgment, that is still the most powerful one in New Zealand for breach of natural justice. Okay, what I've worked out on the abusive process lately is, like with the one I'm doing in the court at the moment, I've told the registrar straight out it's an abusive process because it contains falsities and stuff like that in it. Sort of caught them off guard because they went, we just registrars. So, so I was like, oh god, here I was thinking I was going to get it over and done with that day. But they went, oh, we just registrars, we don't have the ability to dismiss this. So, yeah, okay. But when it comes to those sorts of things, like the breach of natural justice, people wouldn't think of this as being a breach of natural justice. You know, you go to a court and you go to file documents and they go, no, I'm sorry, I'm not going to accept that for filing.
Oh, many times, yes.
Right. So as Jean Grey has proven many a times, and also got it in a judgment, the judge, like how Judge Black stopped us filing memorandums. Okay, that is a breach of natural justice, because you have to have access to justice, and one of those things is filing memorandums, filing paperwork. Okay, so if the court stops you filing paperwork, that's a breach of natural justice, and you have to be able to, like, even if it comes out in a minute that you can't file this or you can't file that, you go and appeal that, because the High Court will tell them straight out, okay, you must accept it. You know, you cannot turn around and say to a person, you can't file. How can they access justice if they can't file?
Exactly. Even if you're kicked out of the courtroom, you still should be able to file.
Oh yeah. I mean, the weird thing was in our case, and we know. Okay, this is where their bias and the being non-impartial comes in. How is it that we go to file a memorandum, the registry comes out and tells us, because of this minute here, we can't let you file. 2 days later, the OT lawyer files a memorandum that goes to the judge.
Yeah, exactly. What's good for one party is good for the other.
Well, it should be, but it never is. But yeah, I mean, I would say to people, when it comes to trying to sort your case out and win your case, unless you know the things that we've learned through our journey, you're not going to have the capability, even with a legal aid lawyer, unless you've got one that's honest, touch wood, and the chances of that is very, very remote.
Can I freeze it open?
No, because hell can freeze over and the lawyer's still not honest.
They'll just sit there and pull out a popsicle, as far as they're concerned.
Well, yeah. I mean, you've got to be able to. I would say, going on what other people have said in regards to certain things and how things work, then I should be qualified lawyer. Because going on the way the psychologist board told me that if they're qualified, they get their bachelor's or whatever in psychology, as long as they read the piece of paper that was put out by the person who's done the DBT or CBT, and they got an understanding of it, then that qualifies them to be able to do it.
Like
and I said, well, that can't be right. And she goes, why is that? Because on that basis, I'm a fully qualified lawyer in QC.
Yeah, exactly. If that's the rule they're going to use.
The main thing that I was going to really say for anyone out there is, when you're going through this journey, all you really have to think about is what I had to make that decision when I did have a lawyer. Going through all this, okay, you're going through it, and where you're getting. You're not really getting anywhere, and I'll be surprised with legal aid if you will ever get anywhere. So, for everyone to say that, you know, they love their kids and everything like that, but the real test is going to be, it's a damn hard journey, but you've got to sack them and go through it. As long as you've got the right support there, and people that you trust there that will be there with you the whole way, like I have mum and dad and a few other people that are from, you know, professional side. So as long as you've got that good support network there, then yeah, you know, you get to have your moments where you have a bit of a cry or whatever, but you have to keep fighting the battle to be able to get your little one home. Because if you don't, they're going to be stuck in the system. And if you know that is going wrong, especially for their best interest, health, safety, well-being, then as much as you can see that, okay, yes, they may be underneath those orders, if those orders are valid, or in our case, you know, they were no longer valid, but they'll say they are, do what's best for your child. If you have to keep them to know that they're safe, then do that, because at the end of the day, do you really want your kids to be statistic?
Yeah, well, I think with your one, your orders had those orders were invalid from June onwards, weren't they? And they still tried to act like they were going for a few more months.
It's that, and the fact that with my daughter, with her getting sick over where she was, and then coming back to me and me getting the treatment she needed, then sending her over with the medication she required, and then they're not giving it to her. Of course, if you're doing the right thing by your child, it doesn't matter, you know, what, to me that stage is like, well, okay, I don't care what the system says, because the system is so corrupt. I've got to do what I need to do for her, and if that means saving her life, there's a few cases going on when that was happening, and mum and dad even told me, look at this case. And it was a very similar situation to my daughter. And yet, those kids unfortunately passed away.
One of those examples
So,
is poor little Malachi.
Of course, that's going to get you as a parent. So you've got to do what you're going to do. If they're going to say, threatening you, oh, well, you know, you're withholding the child, you're breaching orders, will take you back to the court, let them do it. As long as you've got all the evidence to back up that you've been in the right, they did wrong, and you've got all the evidence from the doctors and everything to back yourself up, then do it, because at the end of the day, what do you have to lose? That's the thing, one of the things that Dad mainly said to me throughout this journey is, you know, when I was like, well, yeah, I want to do that, but I'm worried that, you know, they're going to stop her from coming back. And Dad said to me, well, at the end of the day, what you got to look at is, it's your decision, but is it worth her never coming back?
Right.
That could be the difference between, okay, you're going to keep her because she's alive and she's not. So is it really worth listening to what they're saying, or you do what you know is right?
Yeah, exactly. Yeah, it's more of the moral and ethical both that you've got to look at, isn't it? Even though some piece of paper says you can't do this, you can't do that, if you can see your child suffering because of the neglect or someone else is causing, you do what you have to do to defend your kid, irrespective.
Because at the end of the day, whoever that was, whether it be the other side of the whānau or someone else, at the end of the day, they will be able to, they'll go along and no doubt show the child, okay, this will be older, but then you'll be able to show, well, actually, this is the truth, and these are the ones who stuck by you and fought to get you back home safe. Because everything she's been through, she knows this is her safe home. And that's a sad thing for her to have to say that only this is her safe home. She should be able to say both sides of her whānau, she's safe.
You're exactly right. Yeah, both if they're both caring parents, then both places should be safe.
Exactly.
But unfortunately, they end up being fodder, don't they? You know, the kids a lot of the time end up being fodder between one parent to the other, usually as a tool to hurt one from the other. Or they're a money-making machine for a caregiver to make money from.
Yeah, and they're using your child to get what you want rather than what is best for your child. That's the second source of it.
The other thing that I think is a really major one in a lot of parents' cases is, I always hear, but I want this, but I want this. And my answer to that is, show me where in either act it says in the adult's best interest.
Yeah. The acts aren't there for the adults, they're there for the child.
Yeah, and see that, I think Jess is right. The other turning point was when they were OT were trying to make their threats about going back to the court and getting an order to have her uplifted.
Scare tactics. Yep.
I turned around and we sat down and we wrote an email out, and I reminded them that under section 104 and 105, because that's what the judge had said, that we would risk her being uplifted under 104 and 105. But when you look at section 104 and 105, 104 is the effect of the custody order. So when people say my child's subject to a 101 order for day-to-day care, no, they're not. The 101 order, yes, that's there, but 104 gives the effect of the order, not 101.
Right.
So 104 says that a child that is subject to a 101 order is in the day-to-day care as if it were 48.2 of the Care of Children Act, because the OT Act is just based off of the Care of Children Act. Everything's the same, just different sections number. But the important part to know is, and what we wrote up, going by what my understanding of those 104 and 105 are, is that 104 is the effect of the custody order. They say that they'll get the police to come and uplift the child.
There comes the threat. But
it's subject to 105.2. 105.2 says that under 105.1b, 105.1b and c, because 105.1b and c is placement of the child, where the child's going to be placed. So an agreement has to be done as to where the child will be placed. The unfortunate part about it is that 105.1d is cancellation of the agreement. So they can place them back, your children back with you, and then under 105.1d cancel it at any time. The issue that they forgot about in this case, in our case, was for them to be able to implement 104 and 105, they first of all had to have the child placed under 105 1B or C. Neither occurred because there was no agreement to do so. So that removed the ability under 105 1D to involve police and remove the child.
Which goes back to exactly like Jess was saying, agree to nothing.
Yeah. So the what they didn't seem to understand from their own legislation, when a child is placed with a caregiver, if the child is placed under Section 362, not 105 1B or C, because those ones can be cancelled at any time under 105 1D. But the important thing for parents to understand is, if you've got worries about your child, like anyway, okay, and they say we'll go and apply to the court, let them. Where was the agreement for the child to stay with you in the first place? So under 105 1D, there isn't the, like, you've got to have 105 1B and C for the agreement. So if there was no agreement under those two, there's no ability to cancel under 105 1B.
Exactly, so they can go to the court as much as they like, but without the agreement, that's just an empty threat.
It's an empty threat on the basis of 105 section 105 subsection 2 doesn't apply if it's cancelled under 105 1D. And for 105 1D to apply, they had to implement 105 1B and C to place the child. So if you've got the child in your care, you can manage to keep the child in your care for 3 or 4 weeks, you're also establishing the fact that the care and protection concerns can't be what they're stating, because if they were, they would have implemented the 105 and the 104. But remembering there's the inability to, because they never made an agreement for you to have the child. So there's no agreement to cancel it.
Yeah, and the fact that they can't produce an agreement sort of takes the wind out of their sails for everything else.
Well, yeah, it completely knocked the wind out of their sails, because, like, she's just got an update on her IA files again.
Oh,
and
right.
from the records at that particular time, OT were the ones that stated, we don't want to, even though we've got a 101, we don't want to uplift her, traumatise her further, and damage the adult relationships further.
Right, and then
So
that's a key point, isn't it? Doing that OIA request and getting a copy of your file from OT, that's a big one.
Yeah,
I mean, she normally does that every couple of months.
To me, I'd say not only OT, but any agency, any doctors, anything like that you have involved, always OIA them.
Yep.
OIA and Privacy Act request.
Yeah, I'm doing that with the National Intelligence Database at the moment for me.
And as she's found, always request not just your file, but any email communications.
Yeah.
Because they put the email communications separate on the system to your main file.
The full file, including the vault, VAULT.
Yeah. See, people don't know that there's the vault in most of the government organisations, and what the vault is, that's where Darren Cassidy was right. He was the one who told me about the vault. And so we made inquiries to find out about it, and then all of a sudden, hello, you go from 6,000 pages to 9,000 because 3,000 are sitting in the vault.
Mm-hmm.
And so what happens is when they enter like OT, when they enter it into Cyrus, at the end of each day, Cyrus is uploaded to the government vault.
Right.
So, and the good part about getting the vault, you know how they turn around, they go and they change the case notes?
Right.
You can get to see it from the start of when the case note was put in, and when they modified it, and where it's at today. So why have you got these three things when it was supposed to be the one?
Yeah, exactly.
And if you have the hospital involved when doing the request, do it through to the hospital, through the medical records, and also do it through to feedback, because medical records get you the medical records. The feedback part gets you all the communications to and from about your child.
Right.
So that's another important, a lot of information comes from there as well.
Yeah, but the so those are the main things I would say. Like for our case, like you say, it changed when I changed the paperwork, but I also feel that we managed to push them back into the corner rather than us being shoved straight back in the corner. It's the ability to know your rights and implement them. It's one thing to know them, but if you're not willing to implement them, you're never going to see change.
Yeah, you're exactly right. And it's how you put it on paper and implement them in a certain step-by-step fashion makes that difference.
Yeah. And I honestly believe if I hadn't approached them about the consent memorandum, this would have probably gone on for another 4 or 5 years.
Oh yeah, they would have kept making money out of
But
you.
it's using that process, like how they say once you file, you normally talk to the other party, right? So I decided, right, I'll give this a go, and I'll see if I can force them to do what is right by legislation. Then I realised what I'd actually done was, if you look up the family court when it was first implemented in 1974, the family court never used to involve lawyers until a hearing. And so what I decided was, okay, let's see if I can work it in that way to a settlement on the basis of we're mediating it, because the family court process, how they do FDRs, the family dispute resolution, that's supposed to be how the family court works. You're not supposed to have lawyers from the start.
Yeah, you bring the lawyers in, you've got yourself an adversarial fucking passion, whereas if it should be just between the two parties talking with mediation, that's the way it should be.
Yes, and so the way the family court system was originally set up is, you know how they have counsel to assist, right? That's what you have at the hearing. You don't have them before that. But they've gone away from that because we don't make any money that way.
Yeah, of course, they make more money sticking their nose in straight away, don't they?
Oh yeah, what it basically comes down to is, as lawyers, we want to be involved from the very start. Otherwise, how do we screw you over?
Exactly. How can we mislead you properly if we don't get to start off with misleading you down the wrong way for a start? Honestly.
We've got to get into implicit to suit our narrative.
Yeah, because it's all about that narrative. But what you've got to be able to do is push that narrative back on them.